All right. Good afternoon, everyone. Thank you for coming. My name is Tamara Freilich, and this panel will explore the net neutrality debate. And this panel is really going to explore the central question of what kind of internet are we trying to promote, and what vision of the internet will really promote a social justice framework. Because in thinking about the internet, really the only information we have is the current state of affairs. And we really need to consider whether this status quo is something we really want to promote, and whether we really want to promote an entirely neutral playing field if that really is the status quo. The internet, as we heard this morning, is really a central tool in empowering disadvantaged communities and uplifting social development. And it's really one of the most pressing civil rights issues of our time. So this is probably one of the most important issues we can consider right now. And I'm really excited to introduce an esteemed panel of experts. And my short introductions will not do justice to their full accomplishments, so I encourage you all to look in the bios in the program for their full bios. So first, I'd like to introduce Professor Christopher Yu. He's a University of Pennsylvania law professor and one of the foremost leading scholars in the net neutrality debate. Next to him is Ms. Nuala O'Connor. She's the current president and CEO of the Center for Democracy and Technology, and she's an expert in technology policy, privacy, and information governance. Next to her is Mr. Tom Kasky. He's the Chief Policy Counsel at Connected Nation, and he leads research and policy initiatives aimed at expanding broadband availability in underserved areas. And then finally, we have Professor Kevin Werbach, and he is a professor at the Wharton School, a leading scholar in telecommunications policy, wireless communication, and regulation. We're going to do a question and answer session at the end, so if you have any questions, just write them on the cards in the middle of your table, raise them up, and a volunteer will come get them throughout the panel, and then we'll do a Q&A at the end. So in thinking about net neutrality, there's really three questions we want this panel to address. So really, they're on the slide over here. We really want to think about what does the term net neutrality really mean, and do we actually really have it right now? And then what vision of the internet really will promote social justice and promote the ideals of a social justice framework, and does this even necessarily have to include net neutrality? And then finally, we want to consider what kind of government regulation of the internet do we want, or do we even need to promote this vision? So I'm going to start with Professor Yu. You've argued that unfamiliarity with the internet's architecture has caused problems in the current conversation. So if you could please lay the groundwork of the debate for us, and really why are we even talking about this in terms of neutrality?
So as the faculty member here, I will tell my panelists, in the interest of engaging the audience as much as possible, there is no need for us to make eye contact with each other. Please, we will not take it as rude for doing what I just attempted to do there, to make sure that we speak directly into the microphone for the benefit of the audience, because if we look at each other and you don't hear it, we'll feel better, but you won't learn anything. So we will dispense with that pleasantry and just simply talk directly into the microphones to make sure everyone can hear if possible. So the network neutrality debate has been going on for over a decade, and what I would say is it stems from the fundamental concern that network operators that provide service to end users, that is the Verizons and the Comcasts of the world, will use their gatekeeper position to change the content that comes to end users, either by blocking certain forms of content with which they disagree, or by discriminating against it, either making it more expensive or making it slower, or to otherwise have an effect on the mix of information that's available. The idea is the internet's supposed to be this great democratizing force which gives us access to tremendous amounts of content ostensibly on an equal footing, and that we shouldn't be biased by that. Our access to that should not be intermediated by anyone in a position to do that. And that's the sort of the overarching question. There are a bunch of subsidiary questions which have moved around, which is, does this also apply to your right to have any device that you want? In the early debates, that was part of it. Part of what's happening now is not only can there be no discrimination within the Comcast or Verizon or AT&T network? Or then other people have argued we should equalize the way content gets to those networks. As you know, the internet is a network of networks. It's made up of many, many different parts. And it's a question not of equal treatment by any one actor, but equal treatment for the whole service end to end. That has emerged as a major question in the debate. And the other question is, are there legal remedies that are, depending on how you answer the question, are they open? And in fact, there was a major court decision in January of this year that whether we'll get into the merits, but changes the people's perceptions limited about what's possible and what's not possible from a legal standpoint. And so we can get into a very technical discussion about what that is. But in a broad sense, what you've seen is a tremendous outpouring of political support and email. You've seen an endorsement of this position by Senator Obama, then candidate Obama, and now President Obama. And we've seen actually a very active debate about this issue. And the question is, what's going to create the best world for us to live in and to take full advantage of the internet? So that's an attempt to set at a very high level what the issues are. I would like to throw out, given the social justice frame that's appropriate for the Sparrow Symposium, I would like to throw out one idea in which network neutrality actually might not promote the interests of social justice. And it's best understood through a program they're called, to give it the name, it's called zero rating programs, but it should be familiar to anyone who has a T-Mobile phone or at least watches television and sees the T-Mobile ads. T-Mobile is advocating a product called music freedom. In other words, if you have a T-Mobile phone and you stream music, that traffic doesn't count against your data cap. Okay? So the real issue there is, in fact, according to most observers, this is a network neutrality violation. You've effectively made one application, that is streaming music, cheaper than all the others. Why? You don't have to count it against your data cap, and it allows you to buy a cheaper plan or allows you to exhaust it faster. And so that's sort of the modern iteration for us. And the question is, should we block this? You know, is this a form of discrimination that we think is bad? And there's a lot of very interesting things. They actually don't make money off it. It's open to any music provider. They do a lot of things that are quite favorable. The other aspect of this, which I encountered when I was at the Internet Governance Forum in Istanbul this year, is the people who really believe in this type of programs are third world nations, developing nations. Because they're saying is, in fact, their priority is not the quality of the connection you get, it's getting the 4 billion people in the world who currently have no access to the internet on. And that they can't make all that money by charging the end user. Being able to get the advertisers who are selling, and these tend to be what are called, the zero rating programs, the most popular ones are called Facebook Zero or Twitter Zero. They give you a phone, Facebook's the app you see when you get on, and your data to Facebook doesn't count against your data cap. And Wikipedia Zero, a lot of different companies have this, and what they're saying is, we need that support in order to do two things. One, to make connectivity more affordable. And what I would say is it puts the focus on networking as opposed to the edge applications, content applications. So the question is, what's the policy problem? Are we trying to promote content and competition there, or trying to promote greater networking? And the second thing is, the fascinating thing is to make it attractive to have the phone. Because a lot of them, people in the world will say, I don't need that. And then, in fact, there's one of the reasons I'm so glad Tom is here is his organization has done some research that if he doesn't mention it, I will. But I mean, it's an interesting question, which is there's an adoption problem where people don't think they need it, and people say, I don't need an internet connection. But it's like, you can call your grandkids for free, even if they're in another country through this. All of a sudden, they start getting interested in it. And we start to see a much more complex way that actually things like zero rating programs, which technically discriminate in favor of one application over the other, actually are serving some pretty important functions in this world.
Thank you, Professor Yu. So, Ms. O'Connor, CDT is committed to promoting public policies that protect an open, innovative, and free internet. So when you say that net neutrality is needed to protect the individual's interest in a digital world, in considering these questions in the background, what kind of framework are you really envisioning? And feel free to respond to anything Professor Yu said as well, but you'll have time for that later.
That's great. Thank you all so much. So let me describe a little bit where CDT is coming from. The Center for Democracy and Technology is a 20-something-year-old advocacy organization based in Washington, but with offices now around the world, devoted to the preservation and promotion of individual liberty online. And we look at the internet as an enabler of democracy, and we want to infuse democratic values into the structure and the architecture of the internet and its operations, so the policy as well as the technical architecture of the internet. And as we see a world where the internet is not just something that you sit down at your computer to access, but rather is something that is embedded in your daily life, that is in the walls of your home, that is in the dashboard of your car, that is on your wrist and all around you, the idea of an open internet and one that is equally accessible to all humans becomes profoundly important. It is not just how we get our entertainment, but really how we drive our lives and how we access information and opportunity, whether it's information about educational opportunities or information about economic opportunity, and simply information and the ability to communicate with each other. This becomes a profoundly important threshold question: how we are going to regulate or not regulate, how are we going to enforce the democratic values of an open internet architecture. And so CDT has long been on the pro-net neutrality side, and we are engaged very actively both with folks in the technology sector as well as in the telecom sector and in the government, trying to bring people to the table to find common ground on this issue. We are concerned, obviously, and we've always been in favor of a light touch regulatory approach, so we are concerned about over-regulation that would stymie innovation. I'm curious what my other panelists think, so I will throw this out there. The New York Times just posited an analogy that a Title II approach is more like what you get for your electricity services or your water services, whereas a 706 approach makes the internet look more like your cable company. Now, I'm not too sure that many people are that fond of their cable company, so I think that does 706 a great disservice. But when you think about the level of innovation in the provision of your electricity services, you do think, I don't see a lot of creativity in my electricity bill every month. Now, most of you are students still, so you probably aren't dealing with your home utility bills yet. But so we are very concerned, obviously, about the rights of the individual to access services at the lowest possible cost, the ability to enter the market with the least barriers to entry. And we also look at this as a world in which the individual end user is not just in the consumer seat, but is also the creator of content. And so the individual could also be an edge provider, could also be a content creator. And I'm so glad you brought up the zero rating services issue, because we do look at this, because to me it speaks of a global issue. Something that looks like a zero rating service in the US, where there is more plentiful access, is a very different reality than someone in an underserved area of the world, and an underserved population even in the US, who does not have access or cannot afford basic access without some of that additional juice from a zero rating service. So we are torn about those, because it does kind of encourage people to get into one service provider and one set of content, but it does also allow access to the basic platform. So I don't want to sound like Yubera and say we feel very strongly both ways, but we really do want to see a world where there are the lowest barriers to entry for the individual, where there is the greatest protection of free expression, of free speech, and of individual privacy. Those are the core values CDT has long stood for.
Thank you, Ms. O'Connor. So, Mr. Kasky, you seem to argue that neutrality may not actually be the right vision in promoting a world to promote social growth. Could you elaborate on that a little bit and maybe address Professor Yu's data point?
Oh, well, first of all, thanks for the plug, Professor Yu. Like two of my first talking points are already scratched off, so I'm going to be extemporaneous here. First of all, I'd like to extend my appreciation for being invited to speak here today. Really, when Tamara outlined the panel to me, I was actually starting to think a little bit about, how do you think about social justice with regard to a concept such as net neutrality? Because normally when we talk about social justice issue, a word like neutrality tends to become seen, can actually often be seen as non-neutral, right? If we wanted to think about the social positions of various individuals in our society, and we say, okay, you over here, you're starting on the 20-yard line, another group is starting on the 50-yard line, a different group is starting on the other 20-yard line. Now, let's be neutral and see who scores, right? From my own standpoint, I think that we have to be kind of careful when we talk about using words like neutrality as being a definition of an end game or an end state that we really want to be. I think it's actually fascinating that we're following this panel with a discussion that focused on development, by and large. Because again, I had thought about the Wikipedia zero and the Facebook zero and Twitter zero approaches, and that actually may be very good for individuals in third world countries, but probably really bad for the application sector in those countries that may want to start up their own Nigerian version of Facebook. There's going to be 1 billion people in Nigeria not too soon from now. This is one way of thinking about the issue, that there's the potential there, yes, for getting a lot of free access out there, but the nature of what is spoken and how people communicate and use these tools, in my opinion, is actually really as important as the concept of neutrality with regard to the speaking. Just a little bit of my own, the reason why I'm bringing this perspective up. After my time in Washington, D.C., in the last few years, I've been working with states and local communities as they've been developing their own broadband plan and broadband principles. And it's actually kind of fascinating that while the issue of net neutrality does sit out with local communities, and we'll gather in rooms like this in high school gyms in counties in Nevada, it's not really the top of the mind of individuals and communities. What's on the top of the mind is, how do we get better computers into our schools? How do we make sure that when the child has a computer at their school, that when they take it home, that it'll still work and they'll be connected? In this country, there's an astounding number of low-income families with kids who do not have broadband at home. It's the majority, frankly. That's now now we're talking about the internet being a great democratizer, potentially. It also can be the source of extreme inequity and inequality if we give some members of our society, have this benefit of a textbook that's always on and interactive all the time, and then a majority of the poor children don't have that capability when they get it home. And they have to go to parking lots of libraries and hope that the library administrator didn't turn the Wi-Fi access off that night in order to do their homework. I've been in rooms where librarians routinely will write excuse slips to teachers to say, this is why this homework assignment didn't get done. It was because there weren't enough computers in our library, and so the children didn't have the chance to do their online homework today. So just the very idea of librarians writing excuse slips for homework really does demonstrate that when we think about this issue and the way that we think about access to information and how people use the internet, to just be focused on neutrality with regard to making those communications, I think really misses a lot of the social policies that we need to start implementing as a country. So from a neutrality standpoint, I think that we need to, I agree with a lot of elements of both sides of the debate. I don't have a very strong opinion with regard to the net neutrality rules that are before the commission today or that the president has talked about, et cetera. My real concern here is that let's not think of neutrality or the lack thereof as an end in and of itself, because making sure that people have the capacity to communicate is just as important to social justice as whether or not that communication can be enabled via the internet as well.
Thank you, Mr. Kasky. So Professor Werbach, in light of what Mr. Kasky just said, you have the difficult question of now arguing, why do we still want net neutrality?
I don't know that any of us would disagree that we want some form of net neutrality. Let me just back up and say it's terrific. I think it's great that the organizers of this conference had a panel on this topic. Because net neutrality, as Professor Yu said, has been kicking around for more than 10 years. The predecessor issue of internet regulation and broadband regulation was something I worked on when I was at the FCC in 1997. But it's always been a geeky, techie, lawyerly debate. It's been a Silicon Valley debate about innovation and startups. A really important debate, but that kind of debate. And something pretty dramatic changed this year. So the FCC implemented net neutrality rules in 2010. They were overturned mostly in court in January, as Professor Yu said. The FCC chairman proposed a new set of rules that were similar to the previous ones. And there was a huge popular backlash. Lots and lots of people said, no, we're really concerned about this. We are really concerned that these rules allow what we think is an unfair set of practices. And the issue that got people so upset is what's called paid prioritization. Again, a sort of geeky, techie term, The idea that a broadband company, a Comcast or Verizon, might offer someone a so-called fast lane. They might give a content company the opportunity to pay for faster delivery for their content. And what's interesting is you're only concerned about that practice if you really have a strong kind of equity, social justice orientation. It's not saying we're going to slow everyone down. It's not saying we're going to block anyone. It's saying we're going to create a differential, two different kinds of access. And I don't want to get into all the details. We can get into if you want in terms of what, whether that's good and bad. The point is that there was a tremendous degree of opposition to the FCC putting into place rules that might allow that practice, even though it's not in existence today. None of the companies actually do that today. The mere fact that they could was seen as a really significant limitation of this FCC proposal. So that suggests to me that the public cares, and doesn't just care about the innovation consequences, but cares about the access consequences, cares about it because fundamentally this is the internet, as the previous speakers have talked about. This is the informational ecosystem for our society and the global society in the 21st century. So the rules mean a lot. So that's the first general point. There's a lot of debate about the different sources of legal authority, the so-called Section 706 and Title II approach. Fundamentally, I've always been sort of the odd man out in this debate. I don't think it matters that much to what happens because there's no easy solution. So it's good that Professor Yu started us off with the zero rating question. Great question, right? Because you can look at that practice, saying some content is free, or let's say we have a cap, a data cap on your broadband plan. Some content is exempt from the cap. One thing that might lead to is more affordable access. Another thing that might lead to is anti-competitive discrimination, right? Because if companies have unfettered discretion to say, well, this is under the cap and that's not under the cap, maybe they're going to use that as a lever to discriminate against certain companies, certain services, certain things that are not as valuable to them in terms of profits. So it really could cut both ways. And I've always said the fundamental question is whether there is the opportunity to look at these practices, what actually gets done, and determine if they are anti-competitive, if they are unfair, if they are unreasonable forms of discrimination. Because discrimination in an economic sense, the idea that everyone is not charged exactly the same thing, there's nothing fundamentally bad about the fact that you are doing that as long as there's a reason for doing it. So the fact that I pay more for my 50 megabit broadband service than someone else does for their 10 megabit broadband service, that's discrimination, but I don't think anyone would say that the fact that that exists per se is unfair or unreasonable. But there's certainly lots of ways that that could be the case. So the real issue is, do we have an FCC or some other kind of body in a position to look at these practices and to decide what's reasonable and what's not? And I think we're going to get there under either of the sets of rules that are being decided, but that's really an evolution because when this debate got started, it was either we have regulation or no regulation. There's going to be regulation, and it really has been driven not so much by the money coming in from Silicon Valley companies, although they've lobbied just as the broadband industry has lobbied. It's changed because of the tremendous popular outcry.
Thank you, Professor Werbeck. So we now have via video a special guest who is going to make some remarks. He was a little too busy to come, but.
Comcast buffering the connection here?
You can't, actually we have a direct connection. You know, this is, Penn buys a private connection directly to the internet. And so this is one of the interesting problems we have, is that even with a very high-speed connection with multiple uses, and so one of the interesting things is actually Penn prioritizes service. They're very committed to neutrality, but they prioritize two things, public safety communications and environmental controls. You know, and I think
Hi,
this
everybody.
goes in the idea.
Ever since the internet was created, it's been organized around basic principles of openness, fairness, and freedom. There are no gatekeepers deciding which sites you get to access. There are no toll roads on the information superhighway. This set of principles, the idea of net neutrality, and given innovators the
I hope you
chance
can
to
all read
thrive.
lips.
Abandoning these principles would threaten to end the internet as we know it. That's why I'm laying out a plan to keep the internet free and open. And that's why I'm urging the Federal Communications Commission to do everything they can to protect net neutrality for everyone. They should make it clear that whether you use a computer, phone, or tablet, internet providers have a legal obligation not to block or limit your access to a website. Cable companies can't decide which online stores you can shop at or which streaming services you can use. And they can't let any company pay for priority over its competitors. To put these protections in place, I'm asking the FCC to reclassify internet service under Title II of a law known as the Telecommunications Act. In plain English, I'm asking them to recognize that for most Americans, the internet has become an essential part of everyday communication and everyday life. The FCC is an independent agency, and ultimately this decision is theirs alone. But the public has already commented nearly 4 million times, asking the FCC to make sure that consumers, not the cable company, gets to decide which sites they use. Americans are making their voices heard and standing up for the principles that make the internet a powerful force for change. As long as I'm president, that's what I'll be fighting for too.
All right, Professor Yu, I know you have a lot to say about this. So just to start with, President Obama talks about toll keepers or toll roads and gatekeepers. How accurate of concerns are these? And also if you could address Ms. O'Connor's Title II as being electric and
Sure.
706. So.
I'm happy to do both. So the reality for us is that the consumer, one way or the other, pays for the service. Sometimes we pay Comcast, sometimes it's indirect through Netflix, the subscription we pay to our service providers. Sometimes we're buying product because of products advertised in there. But one thing that's a reality to me is the consumer is the end source of all the value here. And on some level, when we talk about free, really it's not free. It's a different pricing structure. And so I would frame the issue a little bit different is, should we have any particular reason that we should price it only in one way? So an example that's often used in the press right now is Netflix has an agreement with Comcast to directly connect, not pass through the internet network of networks, but connect directly to the Comcast network. And they're paying something for that, and they're providing actually better service. That's pretty well established. And my question would be is, how would we want, from a fairness standpoint, this price to be? Well, if Comcast can't charge Netflix, Comcast has to build that into the rate for every single subscriber, regardless of whether they're a Netflix subscriber or not. You could also structure it so that you charge them for the cost of building up bigger pipes, and it shows up in the Netflix bill, so the people who are creating the demand for the higher volume are the people that end up paying for it. And the interesting problem we have here, the reality is if we're going to build out bigger networks, and if we had public funds, we could do it through tax dollars and all that. Right now, we're trying to cut money from the budget, not spend what we estimate is about $300 billion more. And the question is, we have to allow companies, if we expect them to provide higher new services, to find new ways to finance them and new revenue streams. And one of the interesting questions is, how should we have a preset notion of how those revenues should be structured so they can only recover it in some ways and not in others? I would tend to be more flexible. So with the accident last time, I have to give, Tom didn't mention it, he is too modest, I'll give him another plug. Tom's organization is doing what I think is some of the most important work in the nation, which is providing connectivity to rural communities which currently don't have it. I mean, this is very, very important work. And I cannot emphasize importantly as much, we've lost this notion in terms of how those of us who have connections and arguing about the quality of it and what it's like. I think the organization he represents is putting in real commitment. They also did a fascinating study with 2 staffers from the FCC, where right now 30% of American households don't subscribe to broadband. And some people, I was with a panel with Tim Wu, and you really go, oh, they're just cavemen, they don't understand it. No, I think there's real issues here. I don't mean to be as dismissive as that, including substantial families that have the chance to get it, they choose not to. They did a study that found out that of the people who aren't adopted, 2/3 would not take it, even if it were free. So that tells me that we could change the price, we could build it out everywhere. We have an adoption problem that requires a different set of responses than are currently dominating the debate. And so Facebook Zero and all these things actually are responsive to that adoption problem in different ways. And to think about it's just about pricing and a very narrow range, I think is too narrow. The last thing about, is Title II like the phone? Should we apply, it applies to water and electric power, or should it be like cable? Well, it's interesting. People aren't that happy with water and power companies too. I mean, these aren't exactly a wonderful set of industries. But the funny thing that strikes me is basically the Title II proposal would be to regulate the internet the way we regulate and have regulated the phone system. And the big question is, do we think that would make things better or worse? And I think that in many ways we romanticize the phone system. When in the phone system's heyday, that regime is not thought to have done that well. You remember when all phones were only black, and the big innovation was the princess phone and all these other things. The phone system under the traditional regulatory regime has been criticized as being not innovative, not too expensive. I still remember back in the day when I had a high school girlfriend and paid a $500 phone bill once upon a time, and those we haven't seen in a long, long time. And it's interesting, I wouldn't unduly romanticize that, but I also wouldn't say Section 706 would exactly be like the cable world we live in, because actually the cable world bears a lot of resemblances to Title II, and when people advocate network neutrality, they actually draw on the cable examples as analogies of what they want to do. So I don't think that the cable world is a great solution either, but I wouldn't equate what the chairman is proposing with treating the internet like the cable system. I think there's some room for middle ground, and I think people are desperately trying to find middle ground right now, because I think they find the extremes on either side not the most attractive outcomes you could want.
Professor Yu, I'm going to give you 2 more minutes because I have a question for you. So is this alternative a network diversity approach that you argue for?
She's being very nice to me now. She's throwing me a bone. I wrote an article a long time ago which I advocated is based on this. People use the network in different ways. Some people want video. And that's high bandwidth, but doesn't have to have a lot of security. Some people want e-commerce. Some people want financial services, which uses tiny little bandwidth, but needs microsecond latencies and auditable records after the fact. And we all want different things. And the point I would make is, I think the world is better when we have different kinds of networks offering us different sets of services. So most of us don't go, yes, the internet's collected to billions and billions of locations all over the world. We don't go to most of them. In fact, if you dropped off a bunch of the foreign language speaking websites, it wouldn't change the value to me very much. I personally would pay for better connectivity to, I dial into my office all the time, to pull files, my email web server, my bank, ESPN a lot more often than I should, we all got our foibles. But my point is, based on how I use the internet, you would actually enhance its value to me and actually allow me to do something if you would give me better connectivity to those places that I use the most. And the thing I worry about is, could those rules be used to shut off alternatives? Maybe. But I wouldn't want whatever rules we create to prevent us from getting services that are customized to what we want to do. If you want to know, the ISP that has the highest customer satisfaction ratings in the UK is a company called PlusNet. They blatantly prioritize service. And who do they favor? World of Warcraft kids who want to do these online games. Now, what they're doing is, instead of being everything to everybody, they're actually offering a service, a differentiated service that would please a small group of people very, very much. And in a world, if you don't do that, then you're competing on price and scale that can play into the hands of the big guys. And I think you're missing an opportunity to make a bunch of consumers very happy instead of they have 10 ISPs, and a 10th Me Too offering that duplicates what everyone else is doing.
Thank you, Professor Yu. So Ms. O'Connor, Professor Yu, he just talked a lot about a customization. So is this at the cost of impeding minority access? And so do we really still want common carriage classification? So if you could speak to those issues.
First, I just have to say it's a delight to be here, where I feel like there's so much more nuanced conversation than I've been involved
just
in.
Get outside the beltway, it happens very quickly.
I'm
Yes.
still a little traumatized, actually, by the last couple weeks I've had. People have cut me off email lists. I mean, it's been really uncivil. So I'm coming back. So I'm coming back to teach with Professor Yu for his guest lecture for his classes in a couple weeks. And that's the challenge. I can go deep dorky on common carriage and why this is a good and bad thing, and I think I agree with Kevin that the authority matters less than the rules and the principles we're trying to achieve. You're sounding like a good telecom lawyer there, talking about customization and personalization, which I actually think has its benefits. It's a little less sexy than Mark Cuban's tweet this morning that says, you can all be against paid prioritization until your doctor is trying to perform surgery on you with the input from somebody online, and you want that traffic prioritized over your gaming that day. So there are good reasons to want to prioritize, as you said, public safety messages, environmental and health issues. And Title II does not prohibit. I mean, remember, common carriage is common carriage. You can have a first-class cabin. As long as it's available on an equal basis, you can get in. And so I feel like folks who are hardline Title II, although we share their values completely, have overstated the promise of Title II and understated some of the risks. So I look less to the pure common carriage articulation than I do really to what the rules look like should we ever get there, and how they are operationalized by the FCC. I mean, there's a real administrative law question. Setting aside whether the president should be telling an independent agency what to do with its decision-making authority, that's a whole other conversation. But what happens next? When if we ever got to a place where we got a rule that could at least establish peace, and that's a real question, whether we're not just looking, I mean, I said to a telecom lawyer, not kind of sarcastically the other day, I'm like, isn't it your turn to sue? Because the other two have already done their rounds. So even if we were to get to a place, which I am still the most optimistic person in Washington working on this, if that happens, we need rules, we need an articulation, and we need an agency that actually has a consumer enforcement backbone. One of my great concerns around Title II is if we turn this into common carriage, we potentially deprive the Federal Trade Commission of its authority to engage in consumer protection activity. Having been on the receiving end of several actions by the Federal Trade Commission when I was in the private sector at a .com and at a larger organization, I think they've got the bench strength to protect consumer privacy, to protect civil liberties, to do some great work in that area. We potentially stand to lose that bench strength if we move all of this regulation to the Federal Communications Commission. That's not to say they could not build it up, and they are hiring new folks and they are developing some expertise in privacy and showing some muscle there, but they are years behind the FTC in their enforcement authority over internet activity, and in the specialties of privacy and some other related, and data breach and security and that sort of thing. If they were to become more of a consumer protection and more of an advocacy organization, there's a potential there for a greater equilibrium, but that's an area of concern I have about a pure common carriage analysis. We, however, also think that a pure 706 commercially reasonable standard misses the point. I mean, commercially reasonable, and Kevin started to say antitrust, and I the hair on the back of my neck goes up, because I do not think this is it should be the domain of an antitrust law either. We really are trying to preserve the construct of open internet and the individual, and level the playing field a little bit more for the individual, and so we've proposed that if 706 rules were adopted, they would look much more, and this is where we struggle, we do not have a cool name for this, right? You can quibble with net neutrality, but it's really a cool, it's alliterative, it's sexy, people get it, it's really hot. No one really understands what it means outside of this room, right? It's like a Rorschach test. Everybody's got their version of what it means, but it means different things to different people. We need a cool standard under 706 that says, keep the internet open, innovative, and free. We haven't gotten that jargon yet, so I want your help with that.
Thank you, Ms. O'Connor. Mr. Kasky, so if we can see that we do need rules, what rules do we want? You seem skeptical that there ever is a solution, so how can we construct one?
Pick up on Nula's point of view. I've had 2 stints at the commission, at the FCC, and I do share those concerns as to whether or not the FCC could enforce it should it want to. We can even disagree about what we think the rules would be like, but there's a wide range of a lack of expertise and focus on expedition with regard to FCC enforcement authority. And what's fascinating is I think every FCC chairman, since I've been paying attention to this, has said that they need more, and really none have really done it. I think the most interesting appointment recently was by this current chairman, who actually brought in somebody, I think, from the privacy field. Yeah, that was the first time they'd actually not appointed from within in their enforcement bureau, which I thought was very strange. But setting that aside, the last time I was at the commission was in 2009. I was part of the team that was brought in to write the National Broadband Plan. And I remember on was it fascinating work, and for you young attorneys in the office or in here, you know, never turn down a public service offer for something unique. Work with interesting people whenever you can. So our first meeting, we had a group of maybe 30 people working on the plan because we had all of 9 months to do it, and we decided then and there not to talk about net neutrality in the plan. In about 15 minutes, it was discussion, and we solicited views, and it was interesting because the point of view that generally emerged was there are a lot of important issues that we need to be talking about with regard to broadband and technology in this country and in this economy, and that if we have the plan talk about net neutrality and we tell the rest of the world about it, that's all we'll end up talking about. And in the end, invariably, we couldn't really totally avoid it, and I think it popped up in an appendix. Someone told us, they call it the 8th floor. Someone on the 8th floor told us we needed to at least mention, you know, Title II. But we did. But we tried to keep the debate more on the practical aspects of how the commission should do its work, how other government and executive agencies should do their work, because the process matters as much as your setting of your goals and also of setting up of the specific rules. I'll tell you one thing and I agree with Nuala about, you know, Title II. Title II is a pretty flexible framework that is set up. There are some things that are unavoidable with regard to it, but there is a lot of flexibility in the way Title II was applied to telecommunications, and frankly had been applied to internet communication services, you know, dating back even into the 70s. And there is flexibility in that approach. The problem is when you are you assuming or you're betting or you're hoping that you can be flexible enough that you have now put more of an emphasis on the enforcement and the enforcement decisions that you make. And that's where I think the other half of the circle that we started to talk about is that, you know, unless we know exactly how we're going to be enforcing these rules, if we come up with a flexible framework, which is, as Kevin outlined, I think is pretty much what I think we're in agreement on, you know, how that's actually enforced and in what context really becomes the big critical key here. And then we run into an interesting possibility that maybe the rules can only be enforced by aggrieved companies that have the bankroll to bring that suit to DC. And you know, and we all kind of buy into the vision of net neutrality is there for the small entrepreneur in his garage who wants to start up the next Facebook but doesn't want to have to get into a paid system. If we put into place a system where we're essentially asking that guy now to go to Washington, D.C. if he feels aggrieved, that doesn't really necessarily solve the problem that I think we are kind of in agreement needs to be solved and addressed.
Thank you, Mr. Kasky. Professor Werbeck, so you seem to think the larger debate is moving towards issues on pricing. So I'm curious as to your thoughts on the president's comments and Professor Hughes and the rest of the panelists.
Well, I was going to actually turn to Professor Hughes. He was talking. Other than the paid prioritization thing and the Title II thing, is there anything in that statement that the gatekeeper shouldn't tell you what website to go to, your broadband company shouldn't tell you you've got to use this streaming? So is there any of that you would disagree with? Just the principle about.
No.
Okay, and I think that's right. And you know, Christopher is one of the considered one of the stronger academic opponents of net neutrality rules. That's what I'm saying. I think at a fundamental level, the issue of discrimination, gatekeepers, at a high level, there's been tremendous convergence, and I think general agreement that certain practices are illegitimate and they're problematic both at an economic level in terms of stimulating startups and innovation, and also at a societal level, at a philosophical level in terms of freedom and equity and so forth. The challenge is when you get to the details. And the pricing issues are where it gets hard. So I think one set of issues we've already talked about are these zero rating issues where you could argue both sides of it. The other is usage-based pricing issues, and Professor Yu also alluded to this somewhat. If you have a flat rate, if you say all you can eat broadband for X dollars a month at a certain speed, one can argue that that's available to everyone. That's the most neutral, the most fair, the best approach. Or one can argue that that means that the low users are having to subsidize the more intensive users. This is in principle, one can make both arguments and both arguments can be correct. You have to get down to what's really going on specifically. What really are the costs? What really is the barrier? What's the competitive dynamics in this marketplace? And so those are the issues that I think we're going to be fighting about, because that's what's going to happen. And that's what's happened to date. So again, all of the discussion about net neutrality was early on was, well, a broadband company will block a website. They will just say, you cannot go to Google because we've done a deal with Bing. That didn't happen. Because who in their right mind, as a broadband access company, would say you can't go to Google? No one would subscribe to them. What did happen was Comcast and Netflix had a negotiation about what's called interconnection, about the terms under which Netflix connects to the Comcast network. Technically, not part of net neutrality. Net neutrality formally in the FCC rules has been about what happens on the broadband provider's network. This is about what comes into the network. They had a disagreement. They resolved it with a deal that they would directly interconnect, and Netflix would pay for that direct interconnection as opposed to paying intermediaries to get to Comcast. It gets very technical. And that's partly what generated so much of the concern about net neutrality, that it was seen as a gatekeeper behavior. The big problem is it's all done in the dark. All of these agreements, these interconnection agreements, are under NDA. No one can see what they are. And so, looking from the outside, you can tell one of two stories. And that's what we talked about, a lot of these pricing issues. The hard thing is you could describe that as Comcast forced Netflix to pay by extorting them, or you could say two businesses with various choices worked out a deal that was mutually advantageous, both financially and in terms of the performance on the network. And we don't know. And the FCC doesn't really know. And I think that's fundamentally the problem. I'm just making a factual prediction that more and more of the issues we will actually see that are hard issues will look like that. There are issues that come up. I mean, the other example that I wanted to bring up is a few years ago, Verizon Wireless, NARAL, the pro-choice abortion group, went to Verizon Wireless and said, we want a short code for SMS to reach our members. And Verizon Wireless, the response they got was, no, we won't give it to you because we have a policy against something like offensive and controversial activity on our network. You can tell this story one of two ways. One way is, look, this is exactly the reason we need rules to prevent a company like Verizon from using its power to enforce its political views against a particular group. Or you can tell the story as, you know what, this was a low-level employee of Verizon. A day later, when it became public, it got to the higher ups, they immediately reversed themselves, said, sorry, we screwed up, that was not our intent, that's not what the policy is supposed to mean. The public pressure caused them to change very quickly. Most of those issues can get resolved when things come to light. The pricing issues get harder, again, because you've got to really get into the details, the nitty-gritty, and what's really going on.
Thank you, Professor. We're back. So we're going to move to question and answers now. But I know Professor Yu has a question for Ms. O'Connor about Netflix really being the poster child. So I'm going to let him lead the question and answer, and then we'll move on to yours.
Well, one of the fascinating things to me is, we're starting this conversation about network neutrality being about social justice. And as Tom often raised an issue that's often framed, which is, let's protect garage innovators, people who can't afford to pay their way on. But oddly enough, the primary driver, and as a lot of the conversation we've had, is focused on Netflix, which is not really, I think, about social justice and doesn't exactly seem to be the kind of weak, smallish company at now, what, 25 billion or more in market capitalization that this was designed to protect. I mean, that is the basis of the discussion. And I guess my question is, how do we start off talking about democracy and human rights and free speech and end up talking about how much Netflix needs to pay Comcast in order to terminate its traffic?
And that's a question for me?
It can be anyone.
Because I don't know. But I do think it raises a very interesting kind of advocacy question in Washington, and that, first of all, in this debate, people have gotten very polarized over long periods of time, and I got to watch a little bit of this event since I started my new job about the same week the court case came down. So I got to watch this kind of arc, and people just ran to the barricades, right? I mean, both sides, frankly, the tech and the telecom. And you are right. One or both sides might cloak themselves in the language of social justice and equality and that sort of thing. Kevin makes a fair point, which is follow the money is not a bad rule for a lot of these debates, and even in Washington, even around these issues. However, it was a very wise person in advocacy in Washington said to me recently, when the interests of the individual and the companies align, we see real movement, we see real progress. And that is a very interesting thing for me to learn, as I'm relatively new to advocacy and have been in the private sector. We see it in our work on surveillance and the other issues that the other portfolio of issues we have at CDT, that it takes loud voices, big and small, to make change. So whether theirs may be disingenuous and mine is deeply held as an individual, when the interests align, the balls really move.
Thank you. Does anyone else have a response to Professor Yu's question?
No, I think it's a wonderful response. Just be careful that you don't get so aligned to understand that where they may peel off at another point, because what's fascinating to me is Netflix, we started talking about treatment within the networks. They're the big push to expand beyond it to make it about interconnection generally. And that is a big move. And it's not clear to me whether in that move the interests of CDT are completely aligned with them. And so I understand political processes are all about coalition buildings, and you don't choose your coalition partners, you find people, common ground. You just have to be aware, you look for where the common ground is, but at the same time you have to make sure that you know where the common ground isn't and when it goes too far.
So I've been surprised by people peeling off from coalitions, but it hasn't necessarily been companies lately. So, but it's good advice for Washington in general.
Yeah, maybe if I can take it in a slightly different direction that might be particularly relevant for this group, not about Netflix, but the other interest groups and advocacy groups that are always in an interesting position in these issues are civil rights and minority groups, which traditionally in telecom policy debates have often been on the side of the carriers, on the side of the phone and cable companies. It puts them in a challenging position because a lot of their constituencies and a lot of their allies on other issues are the progressive groups that say, we need to regulate these companies, they're too big, they're too powerful. But on the other hand, a lot of these companies they've received funding and support, and they also from the broadband companies, and they also, I think, legitimately see a point of view that too much regulation, for some of the reasons Professor Yu talked about, can also be harmful in general and especially to these underserved communities. So I think that's going to be interesting to watch. And these groups get pulled on both sides on this. Because really, from a political standpoint, those are really the only powerful, or maybe not powerful, the only significant, important constituencies on the left, on the Democratic side, that have been pushing against this view that we need a Title II approach or a more regulatory approach.
To put meat on it, the NAACP filed against Title II in the proceeding. The Communications Workers of America, the labor unions, filed against Title II, mostly because because they think that it'll hurt jobs, and the NAACP is because the minority communities don't use media the same way the rest of us do. They over-index in terms of, they use wireless much more heavily, they use social media much more heavily. They have a different use profile. And they're taking the position that they may want, instead of a connection that's sort of generically everything for everybody, they might want a product that reflects a slightly different use pattern. And that's fascinating to me. I will also comment that even though they filed that way, they have not been very vocal or visible in the debates. And this is a very strange political time. So I mean, one of the odd things about this is Google has been virtually silent. Google in the first generation has been quite out front. And the interpretation that I think that makes the most sense is they're either ambivalent or they're opposed, and but they don't want to be turned into a pariah. And so what you'll see is a lot of these big companies, you notice, aren't the poster children. They aren't in front. The people in front are this little tiny web retailer called Etsy, which I'd never heard of before I met them in testimony. And it's a nice, I mean, it's important, and they have a legitimate point of view, but my point is they're hardly the typical well-funded DC presence that normally carries water on these issues. And Netflix. And Netflix is a very distinctive position because they are 1/3 of the internet by themselves. I mean, they are an enormous source of traffic. And when I read the tea leaves, and I know really no inside information here, it's quite striking who doesn't talk as well as who talk, or in the case of the Labor and the NAACP, they talk but not that loudly and persistently. And there's some politics here that people are trying to navigate that are quite exquisite.
I think one of the reasons you see a lot of the traditional civil rights group almost kind of sit on the sideline for the most part on this really has to do with the fact that while it is an important issue, an important civil rights issue, there are larger civil rights issues that are facing the telecommunications industry. To the extent that they think about broadband, those that represent low-income and minorities need to be thinking about the Lifeline Universal Service Fund, which is now 30% lower than it was at the beginning of the Great Recession, and which is the mechanism that got the last 15% of the people on the voice network in terms of trying to get that adjusted for broadband services. One of the states that I work with, or jurisdictions I work with, is Puerto Rico, where this is a really interesting debate to have in Puerto Rico, but only 1 in 3 Puerto Rican households is online right now. 1 in 3, and they're U.S. citizens, and so the tenor of the discussion and debate in Puerto Rico about this issue, as compared to the issue relating to expanding Lifeline program to broadband, or the E-rate program to make sure that schools, the other interesting fact about Puerto Rico, not a single high school or elementary school has faster than a T1 connection today. Largest single school district in the country is on the island of Puerto Rico, and that's the most that they have. And so the social justice issues that they face on an everyday basis, I don't really want to diminish the purpose of the panel, but really kind of puts it in a bit of a different perspective. And I think that's why you see a lot of the groups will say, well, we have a position, and I agree with it. I think you could apply Rawls to this and come up in favor of a form of net neutrality, but you're still going to be much more concerned about the 2 and 3 households in Puerto Rico that don't have any form of broadband access today, and the fact that none of the children do when they go to school.
Thank you. So I've kind of combined some of your questions, but one that stands out is, so the Title II regulation comes with high taxes, such as a 16.1% universal service fee. Isn't net neutrality merely a Trojan horse to increase tax revenue and thereby increase consumers' internet service bills? So you could speak to the veracity of this statement and the implications.
I know more about that statement than I'd care to admit. But, that wasn't mine. 2 things on that. First of all, it wouldn't be 16%. If you never want to go hungry as a lawyer, get into telecommunications law, okay? Because I'm now into a different job talking about this. But we fund our universal service programs through basically what looks like an end user charge. It's a revenue assessment. You all see it on your bill, and you use that word that you don't really understand. And it's $5 when you thought you were paying 40. But that fee is set on a pay-as-you-go basis based on truly looking forward in terms of how much revenue can I assess, how much do I need to spend, and it's simple math. They apply a factor. So it wouldn't be 16% if they were to expand what's called the contribution base. Right now, the only thing that you pay that tax off of is your interstate and international telecommunication service component of your telephone bill, right? I'm sure you all know exactly what that is. If we were to expand that base to include your broadband service, to include your voicemail service, to include all the other thing, the percentage would definitely go down. The reason it's so high is that the contribution base is something like 1/4 of what it was when we said.
Yeah, it's also it's not a tax in the sense that the government gets the money to do whatever they want with it. It's a cross-subsidy.
It's a pay-as-you-go.
Well, but it's not just pay-as-you-go. It goes into funds that support high-cost service. in certain areas. So it's not the, I mean, I think the notion, the question that the government wants to increase its tax revenue somehow to close the deficit. It's a self-contained program that cross-subsidizes telephone and now broadband.
It's approximately $8 billion a year. The other kind of, the FCC also doesn't need a Trojan horse to do this. They're going to expand that contribution base regardless of what net neutrality rules they set within the next 2 to 3 years. So I don't think they need to do Title II in order to change that. In fact, they probably don't want to.
I would agree. I mean, I don't think this is a subterfuge for raising taxes. It does point out 2 problems with Title II. One, we're going to take a regime designed for a different technology in a different era and put it on a new world. And then we'll have to nip and tuck, but then the people who want to make the adjustments have to have the burden of proof of changing it. And that's a problem, I think, because this is the internet's been very different, and a lot of people believe it's different because it was done with a light touch. To put it, boil it down, the default answer for the internet has been, if you want to do an innovation, the answer has been yes, unless something really bad has happened. Then if someone shows something bad, you go to no. But the default answer is yes. You can do what you can dream. Jeff Pulver, who created VoIP and created what became Vonage, said, I'm a dreamer, and I just love the fact that I could just try new things. Title II would make the default answer no, unless the FCC says yes, and gives you this thing called forbearance. They agreed to hold back on certain regulation. And Jeff said simply, I'll still dream, I'll just do it elsewhere, because I don't have the time to file paperwork in DC to try something new. And this is the change of permissionless innovation that I worry about the Title II frame, because it has a set of rules we'll import from telephone. And unless we go through an administrative proceeding, which by definition, under good terms, will take 6 months, and will probably longer and may become politicized for all the different pulls that happen in agencies, that will cause a world in which people who come up with the idea where the answer used to be yes, and now the answer is no.
Ms. O'Connor, do you have any comment to that? Otherwise, all these questions are directed at you. So it seems like a lot of you in the audience are really curious about whether it's possible to even have a free and open internet with growing monopolies like Comcast. And isn't the main problem just low competitive markets? So Ms. O'Connor, if you could speak to that first, please.
I do think the issue of scarcity of resources is really at the kind of threshold level here. If we had all the bandwidth we wanted, if we had all the deployment we wanted, we wouldn't be fighting over buffering and a scarce resource. So I think the question is, I'm thinking as you're describing the work you're doing with Tennessee Valley Authority and the great government innovations in previous decades, and thinking somewhat regretfully that we've come to this point in the conversation instead of going to really the threshold, which is why isn't there more available in the places where we need it. It is, I do agree, although it is almost a hackneyed line in Washington that trying to fit the Telecommunications Act of 1934 into this new environment and this new technology is a bad fit. What other choice do we have, though, right? Like, it is the less, I wouldn't say it's the lesser of two evils, it is the playing field we're on. And at this point, I'd rather see a deal, and the difference is we do lots of different things at CDT, so our entire identity is not invested in this fight the way others in this fight are. And so I want to finish this and move on to other really, really important things like the NSA and, your personal privacy and the, what we call not the Internet of Things, but the Internet of People and the great new healthcare devices that are coming online and education and student data. I mean, there's so many other things to do with our time that fighting between 2 and 706 is really getting old fast for all of us. What are our other choices, though? I mean, you said to me before we started, is anyone still in favor of the hybrid? I may be the last person even to say the word hybrid out loud in Washington. So I'm curious why, what if not this, then what?
So my reaction is we've regulated under what we call Title I, that's the alternative to Title II, for 30 years. Going back to the Enhanced Services Order of '84, literally 30 years, as it turns out. And that, we are the only country in the world that did not default regulate the internet with the telephone reg system. I mean, Asia does it, Europe does it, everyone else does it. And they all want to know, where is the Facebook of Europe? Where is the Google of Europe? And their connectivity is so much, they invest half as much per household in internet connectivity than the US does. And in fact, they are very frustrated by that. And so the question is, if you want a real world example, and there's a lot of contextual differences, I understand that, but just in terms of superficial plausibility, I think that by decoupling the internet from previous regulatory regimes, that decision was one of the most important decisions we as a country made in our communications policy. And in many ways, I see the current debate is about going back on what has been a 30-year consensus and trying to bring it back in the old rules. I don't know what all the Title I rules are. I would rather have the debate about fashioning internet-specific rules under Title I instead of looking at the legal rules of Title II and look at what the legal standard written for a different era, which didn't, in a statute that only mentioned the internet when it was talking about porn, to see how those rules say, do you meet the legal standard to relax this and relax that? I think the old world worked a lot better, and I'd rather have the discussion about how to update that, make that work better than to go to Title II.
Yeah, except.
Anyway, can I just,
Yes, please.
those are very good answers. I don't think either of them answered the question. The question was essentially companies like Comcast, do they have too much power, not enough competition? And I think we don't have enough competition for broadband in this country. And if we had more competition and real alternatives, then a lot of these problems would be less. But then that begs the question of how you get there. And so that's a whole challenging set of issues. We have the market that we have, partly through a set of decisions that got made long ago, partly because of the economics, that it's really tough to build a competing network into every home in America. There are things like Google Fiber, there are wireless alternatives that are starting to grow that are, might alleviate the problem to some extent, but for the foreseeable future, we're going to have a limited set of competitive options, especially for real fast, high-speed broadband. Can you have a free and open internet in that environment? Sure. We have a free and open telephone network, even though we had a monopoly, legally enforceable AT&T monopoly in most of the country for 60 years, because we had rules that said AT&T is a common carrier. They can't decide not to carry someone's phone calls or to charge in discriminatory ways that are not reasonable. So yes, we can have a free and open environment. We also have some markets. I mean, look at the internet market. Google has a dominant 70+% share or more of the search engine market, and that has not budged despite lots of competition. We still have a free and open internet. So I think we can, but I think the competition issue is still definitely something that we need to always keep in mind, that that's something that needs to be addressed.
Can I answer the question directly?
Yes, you have 30 seconds.
Okay.
Timing.
Two things. If you actually look at the data collected by the government, and data, always people argue with it, but this is people done under the stimulus package in good faith, shows two things. One is that the mapping study says 55% of American households have choice of 3 fixed line providers. And that's at the census block level, measured block by block. And so I think that we have an issue about connectivity. I think it could be more, and if you look at the direction of it, it's actually getting better. So I'm not completely despairing of that. But the most important thing is what Kevin said is, if this debate were about how to get more competition to Comcast and Verizon, I would be thrilled. That's not the terms of the debate. The debate is how do we protect Netflix and Google, which is the wrong policy question to me. The real question is the one that Kevin has identified.
With that, we're going to wrap up the panel. So join me in thanking our panelists, and we're going to move on to the next one.